I hope that you don't dig yourself such a hole that you will never get out of. But that's what DWIs are. Invariably, if it continues, at some point, you may eventually kill someone. Mr. Martinez, let me tell you, you scare me. It's individuals like you that just don't get it, how dangerous DWIs truly are, because you continue to do what you're doing, and you may truly have a problem. I hope that you don't dig yourself such a hole that you will never get out of. But that's what DWIs are. Invariably, if it continues, at some point, you may eventually kill someone. It's not fair. Don't. If you're going to drink, if you're going to get lit, if you're going to have 32 beers, stay the flip home. If you have to go out, take an Uber. Is it so hard? All you have to do is push one button on your phone and someone will take you home. With all the baggage that you have on your record now, if you ever get pulled over and an officer smells even one smidgen of alcohol, they're going to take you in. And from now on, you were looking at a felony offense of 2 to 10 in the penitentiary. So if you don't get it now, perhaps prison is what you need. You're young. You're going to be driving for the next 30 years. Get a clue. Do you understand?
Yes, Your Honor.
Yes, Your Honor.
The only reason I'm doing this now is because you're on probation for the next 2 years in another county. Otherwise, this would not be happening now. Take note and try to better yourself. It's not hard. All we're asking you to do is don't kill someone. Don't get into a car. You're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. It's going to be there for the rest of your life. Somehow I have to get through to you. What I'm going to do to you now is you will be required to pay the DPS fines and fees of around $4,500. And if you don't pay it, every $100 you owe, you will sit 1 day in jail. Do you understand? I am also suspending your ability to drive for a year. Do not get into a car. If I see you back in here, it's really not going to go well. Do you understand?
Yes, Judge.
I'm not asking for much. If you have a problem with alcohol, address it. That's all I'm asking to do. I'm literally, don't kill someone. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a .15 or above? Okay, true to the enhancement. All right, Mr. Martinez, make us proud. That's all we're asking you to do. All right, let's see the clerk.
Thank you, Judge.
Thank you.
May I excuse me?
Yeah. 2-year payment plan. That's okay, Billy. Hey, do you know who the arraignments are?
Yeah, you ready?
Yeah, let's do it,
Okay.
please. Hey,
First one is about Jeffrey Atkins. Jeffrey Atkins, probably.
do we not, do you know if Felicia's here by chance? Pre-trial, Felicia?
Trying for free trial this morning. Good morning.
Okay, Alex, you ready? You want to start real quick? You were Jeffrey Atkins. Mr. Atkins, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Hey, good morning. This is Mr. Atkins, Atkins.
So on February 3rd, 2025, officers were dispatched for a theft. The witness stated he saw a black male steal a leaf blower from his driveway in Kingwood in Harris County, Texas, and place it in his vehicle's trunk. The suspect then got inside the back seat, and a traffic stop was initiated for the vehicle due to an on-view crime. The officer made commands for the individuals inside the vehicle to exit and lay on the ground until backup officers arrived. Both individuals were detained, and the defendant, the driver, was identified by Texas driver's license, and the officer located a firearm on the driver's side floorboard under the seat unholstered. The leaf blower was recovered from the trunk.
So we have a co-defendant.
So let me see. If there is a co-defendant in it. There is no other connected case, Your Honor.
No?
Yes.
Mr. Atkins, I'm going to find that there's probable cause to go forward with your case, sir. How old are you? I'm ordering you as a condition of your bond not to be in possession of weapons. You understand, sir? Did you want to apply for a court-appointed lawyer?
No.
Okay. Miranda's going to give you an application. I need you to fill it out for me. Do not, look at me. Do not pick up any new cases. Don't become a danger to my community. Otherwise, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sir.
No
Sir.
weapons. All right, come on. Do you mind filing that, please?
Yes.
All right. I'm going to have you go with Deputy Miranda. We'll have you sign a reset with Billy, and then I'll have you take a seat out there. Mr. Holt, this is your gentleman, huh?
Yes, Chicago. Could you give me just a moment?
Is he not here?
He is here.
Okay,
I just need a moment for you, so.
okay.
Don't mind.
Yeah, we need to do probable cause at some point, though.
Yes,
So,
sir.
okay, just, I guess, let me know when you're ready. We're about to pick a jury, too, so just be ready.
It won't take a second.
Okay, take your time. Yeah.
Any bond
No, I guess, well, let's find out like a specific spot over there, since we're gonna have a jury coming in soon. Sure. You are Benny Boston.
Yes, sir.
Mr. Boston, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 4th, 2025, at approximately 2:22 a.m., the officer observed a vehicle on East Sam Houston Parkway in the Feeder Road, failed to complete a stop at an intersection. A traffic stop was initiated, and the defendant, the driver and sole occupant of the vehicle, gave the officer his Texas driver's license. The officer found the driver's license to not be eligible, and the defendant had an active enforcement suspension for a DWLI that ends in April 23rd, 2025.
Mr. Boston, I'm going to find that there's probable cause to go forward with the case. I'm now having you sign an affidavit. This is a promise to me that you're going to make that you're not going to drive today. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance, and then I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Sir.
Tell me, do you have the ability to hire lawyers, sir?
Yeah, man. I think I get a court appointed.
Well, we just don't give them out like it's candy. You have to qualify. So what I can do is I can have you fill out an application. I'll take a look at it, but be honest on the application. I need to know everything about you and I'll see whether you qualify. All right. So Deputy Miranda is going to give an application. I'm going to have you come up here, swear to us that you're not going to drive, and then I'll have you sign a reset with Billy and then we'll get with you. Did you just get out of jail?
Yes, sir.
When? Okay. You didn't just get out of jail. When you come to court, come dressed appropriately. Shorts is not appropriate for court. It's a complete sign of disrespect. You understand? Okay. If you do it again, I'm going to put you out. You're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right?
Yes, Judge. On February 3rd, 2025, at approximately 11:53 p.m., the officer observed a vehicle on a public road with a defective front left headlamp. and the officer ran a check on the vehicle and a return with unconfirmed insurance. A traffic stop was initiated, and the defendant quickly exited the vehicle, and the officer gave multiple commands for him to get back inside and shut the door. The defendant stated he wasn't going to, and the officer had no reason to pull him over. The defendant then walked back and got inside the vehicle, but held his feet outside the car and did not shut the door. From the officer's trained experience, he has seen situations where the driver sit like that, then leap from the car and try to hurt officers, and the defendant put his feet into the car and the officer approached. The vehicle had 2 young children, but not a car seat, standing in the front passenger seat, and the officer asked the defendant several times for his name, and the defendant stated he could not because the officer was fucking with him. The officer informed the defendant of the legitimate reason for the traffic stop, and the defendant continued to refuse to provide his name. The officer asked the defendant to exit the vehicle, and the defendant then refused. The officer went to grab the defendant's wrist, and the defendant pulled away from the officer and other deputies. The deputies advised the defendant that he was going to be tased, and the defendant exited the vehicle. The defendant stated he wasn't going in handcuffs and resisted by tensing his arms and body and concealing his hands towards his front waistband. The defendant was taken to the ground where he continued to resist. After several commands, the defendant was going to be tased. The defendant finally put his hands behind his back.
All right, Mr. Collier, I'm going to find that there's probable cause to go forward with your case. Can you run his license to see if he has a valid Texas driver license?
I'll run it right now, Your Honor. It's eligible, Your Honor.
Mr. Collier, I'm going to find that there's probable cause to go forward with your case. I'm not putting any conditions on your bond. Just be careful. You get into a pissing match with people who have the power of arrest. Who's going to win? You know what I mean?
Sir.
Just, it's a logical conclusion. That's all it is. Just be careful when you're out there. Life's hard enough. As an African-American in today's society, don't make it any harder, you know?
Sir.
Do you want to apply for an appointed lawyer?
Sir.
All right, I'm going to give you an application. I'll have you sign an receipt with Billy. I'm not putting any conditions on your bond. Just be careful. That's it. All right? Come on, man.
Rory Johnson.
Hold on, Billy, because I think Mr. Holt is, are you ready? All right, come on. So you have Mr. Blanco.
Yes, Your Honor.
Hugo Blanco, come up. Good morning, Mr. Blanco. Sir, you're charged with terroristic threat on a public servant. That elevates it to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
It's Judge. On February 3rd, 2024, the officer was dispatched to Eastside Transportation and made contact with the complainant, a bus driver. The complainant explained that she made an exception to her usual route to drop off a student closer to home. When the complainant was halfway to the student's home, she opened the doors to let the student off, and the defendant approached the bus doors and appeared to grip an area where his firearm was located at his hip. The defendant asked the complainant if she planned to write up his daughter, and the complainant said yes. The defendant then took a few steps back and lifted his shirt to expose his firearm while making threatening statements. The complainant was in fear for her life and did not want to come back to work, and the officer confirmed the incident by bus camera footage. And specifically, the defendant lifted his shirt to expose his firearm while continuing to make threatening statements, telling the complainant, "I got you." And then seeing the firearm, the complainant quickly closed the bus doors to leave, and as they were closing, the defendant lifted his shirt again to display the firearm, still repeating, "I got you."
Mr. Blanco, I'm going to find that there's probable cause to go forward with the case. Look, I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? As long as you can abide by these conditions, you and I will be fine. If I find that you pick up a new case, you have any kind of weapons, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Now you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're, ducking and dodging and playing games, I will issue a warrant for your arrest. I'm not asking much. I just want my public to be safe. You understand? All right. So I'm going to have you sign a receipt with Billy. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right. You found no weapons, please.
No.
And then no contact.
No contact.
Yeah, please. Mr. Holt,
Yes,
I
sir.
forgot to tell him no contact with the complaining witness. If you mind, please tell him.
Yes, Your Honor.
Thanks.
Smith.
Hi.
Morning, Judge Mayor.
Yes, tell.
My name's Sabir Fareed. I'm just going to be covering until Deanna gets here. She's just running a few minutes late. I'm the chief in court 8 next door.
Okay, thanks.
Thank you so much.
We have a panel coming, any minute, I think, so,
Sounds good.
yeah. Okay, thanks. Ready?
Rory Johnson, step up, please.
Coming up, Mr. Johnson, right here. Mr. Johnson, you were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present and be cannot afford one. One will be appointed to you, sir.
Yes, Judge. On February 3rd, 2025, the officer observed a vehicle with no proof of financial responsibility. The officer also observed the registered owner of the vehicle to have an open warrant out of Harris County. The vehicle ran a red light and stopped past the designated stopping point, and the vehicle turned north, driving quickly as to elude the officer's patrol vehicle. The defendant pulled into a driveway. The defendant got out of the driver's seat as the officer attempted to initiate a traffic stop with emergency equipment for the traffic violations and conduct the investigation. The officer told the defendant to come to him, and the defendant began to evade on foot. The officer told the defendant to stop, but the defendant continued running, jumping over fences before he was taken into custody. The defendant evaded for approximately 100 to 200 yards and was identified based on his ID and name.
What was the basis of the stop again?
So no proof of financial responsibility and running a red light.
Got it. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with the case. I'm telling you now, you're extremely lucky that this is a misdemeanor. You know, this is your third. On a second, it's a felony offense. You're very lucky. Can you run his license, please?
It's ineligible, not eligible, Your Honor.
Have you signed an affidavit with me today, Mr. Johnson? I don't care what's going on in your life. Do not drive. Do you understand? This is an affidavit that you're going to be promising me you're not going to drive. If you want to drive, go get a license, get liability insurance, and I will take this restriction off. But if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do you have the ability to hire a lawyer, Mr. Johnson? So I'll have you fill out an application. I'll take a look at it to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Billy to sign a reset, and then we'll take a look, fill it out. Don't pick up any new cases. Do you understand?
Sure.
You are lucky that this is not a felony offense right now as it is. So
What was the ordinance that was read?
do you have any THAs? Do you know? Has anyone not checked in?
No, sorry. What's your last name, sir? Sorry. What's your last name? John. Brandon Johnson. Is your name Rory Johnson? Someone can confirm that you are operating a motor vehicle at a valid test of driver's license and no driving with flow laws of the correctly. Go ahead and sign your reset with me. Just sign your reset with the lady.
We have Mr. Butler here on the trial case today. This is Mr. Butler on the trial case today.
Yeah, we know it's done.
Okay. I guess you want to wait for McKinsey?
Yeah, and may I make a suggestion too?
Sure.
So I want to give you a little roadmap and just, I've got a suggestion, something we could do. I've got a motion to exclude the drug test. I've got several, but the first one I think is pretty below hanging fruit. Like one that would be easy enough for you to actually read the motion. Review the video can take you specifically to that section. And it's a easy decision.
What say you?
Like to make a motion.
Yeah,
Yes.
so.
Have you seen what he's talking about? No?
No, I just.
I understand.
So we could maybe go back and sit down and that for a moment, now let it back there and I can show it for you and you can maybe work from there.
Take your time.
Yeah.
Thank you.
Oh, okay, yeah.
Okay. Here's two copies for you guys, and I'll leave one in the state.
That's right.
We can get some more.
I'll need it done. Yes.
Actually, I'll get.
And Judge, I've got somebody on the way that, should be here shortly. I'll pick the
Sure.
other set of eyes.
Who do you have
About
coming?
the rain, you know what, out there.
Does it really?
Yeah, like it's really getting dark. And
Who do you have coming? Sit.
Annette Hernandez, it's just my assistant.
Okay.
Yeah, she was at the office covering the phones this morning and we had somebody up sick. Yeah, and I've only got two pieces, so she's just gonna forward me.
Okay.
Help me out a little bit.
And there's the change right here. See behind us? There's a change right here. You got it.
Hey, what's up?
I was just in the neighborhood, so I thought, I don't know if this is something we can do without my client, but I wanted to just check it while it's across the hall. I've got a young kid who's in high school, living at his parents' house. He's on house arrest with a laundry list.
I remember the one kid.
He needs to take his SAT test to try to get into college. That is March the 8th. I just wanted to approach and make sure
Okay with
that
that.
you're kosher. Okay, much
Yeah,
obliged. Thank you.
Absolutely. Let them know, and for the time that he needs to go out, we're okay with that.
I know everybody wants to go take the SATs. Thank you, Judge.
Have to.
We did. We've all paid our dues. Thank you, Judge.
Absolutely. Marcos, you ready?
I'm waiting on
Not yet.
just to pick up.
Not yet, Your Honor, the paperwork's not ready.
Do you have a copy, Marcos?
Yes, Judge.
The flag here?
Excuse me.
Yes.
Who is it on? Oh, is it the gentleman from the back?
He's
Oh, he's out. Okay.
he's.
Did we do a TRAS?
Yes, so he's been in custody now. Bottom line, Judge Yonkers is 21 days. Credit for 7.
I don't know if I'm gonna take a time served on someone who's got an open DWI in another county and he's got a DWI here and he's got,
It's not open over there, Judge. He's not open. It's not open over there. He's not open over there. And he told me he's reporting once a week to some sort of a treatment over there. It's the 22-month probation in Tarrant County. And he lives in Tarrant County. His family's in Tarrant County.
signature.
Thank you, Judge.
So it's 22 months over there. His family's over there. He has to report. He was just telling me once a week to, I don't know exactly what it is. I'm thinking some sort of treatment. And for him to come down here constantly is just, it's not feasible for him. So that's why I thought, you know what, let's just close him out. Yes, he'll have 2 convictions, but he'll be in Tarrant County. He'll take care of that. He'll get, help over there and then he'll be done.
He said he has how much credit?
He should have 7 days.
We did do a TRAS though, right?
Yes.
What did the TRAS recommend? I'm assuming residential?
Community, not, oh, I guess that's different then.
By IOP SSC, because they took into consideration he doesn't live here, it's immigration status and all of that. Because he's very for social court and he didn't qualify.
Because of the immigration issue? Or what?
Because he lived in Tarrant County as well.
Hmm.
The community residential is what they came up
I don't know, Marcos. Every time we deviate from that, it explodes. It literally just,
What if I find out? What if we reset him so I can get more information from Tarrant County? And talk to his probation officer and figure out exactly what he's going to be doing over there. And then if it's similar to this and he's getting the treatment, then
but this is residential. They're not doing it. Otherwise, he would be in it right now. I doubt that because they already pled him, right? I don't even know if they knew that this thing was open. So they're just,
I'm sure they did.
I mean, I don't know. I mean, we can't speculate on things, right? Because it's just. Thanks.
Mr. Butler.
Thank you.
All right. I mean, who's next one's a felon. I mean, they'll have to deal with that, I guess. All right.
Understand.
Okay, Mark.
Bring them up.
You ready?
I need to come.
Oh, sorry. Yes. Sorry about that.
Yeah, she's here. She just left.
Did you read his motion to suppress?
I did. I'm sure Mackenzie did.
I was working in, that.
I'm starting here.
Yeah, what's stone? Working with.
That's so funny. Who made that? Okay, there it is.
Wonderful, yeah.
I do it.
Frank, you ready?
John.
Do you need a translator?
No, he speaks English.
Come on up, sir. This is
Lenin Arauz.
Arauz.
Arauz. It's a .09, Judge, but just let you know.
Shh. You are Mr. Arauz. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, I had to wait probable cause unless you want to hear it.
Anything egregious? She said
No, it's
109.
Point zero
Judge,
nine.
the vehicle had driven up to the sidewalk, but other than that, it is a .097.
Okay. So there is probable cause to go forward with your case, Mr. Arauz. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. No more PR bonds. Do you understand? Does he have a valid Texas driver license?
Yes, Judge, and I'd like to bring something else to the attention of the court. It was 6:30 in the morning and he is 17.
Oof. No more. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand? No alcohol, no illegal drugs, and I'm going to test you. If you don't believe me, ask Frank. I don't want you using at all. I don't care where you're going, what you're doing. Do you understand? Okay. All right, I'm going to have you meet with Felicia for your bond conditions, and then we'll send you on your way. Because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you have to stay in touch with Frank, and he'll tell you when you have to come back to court. If he tells me that you start playing games, you pick up a new case, you don't remain in contact with him, I'm going to issue a warrant. You understand? Okay, man. Good luck.
Judge, have a good
Sorry,
day.
I would
Frank.
just like to request if possible, if we could put in his bond conditions to continue going to school.
Yeah, I'm down with that. Is he in high school?
Yes, Your Honor.
Okay, it's a condition of your bond that you remain in high school as well, all right? You either work full-time or you're in high school full-time. You know, when
He
you
is
have,
working full-time, Judge. He does work.
if you're in high school, right? When you have too much time on your hands, people become self-destructive. So you need to occupy your time, do something worthwhile. All right?
Yes, sir.
Okay, bud. Good luck.
Thanks, Judge.
So Felicia, what did Mr. Gomez test positive for?
Results came back presumptively for THC and cocaine.
Unacceptable. I am now, you have a bond violation for tampering with your device. I now send you for a drug test. You test positive for cocaine and THC. Nope. Goes with you.
Judge, if I may, may I make some argument, Judge? Okay. Judge, so he is a plumber. Part of his duties as a plumber is sometimes he has to work in water. Because he has a device, he has to wear long rubber boots. The day of the tamper was a Tuesday, and it was during work hours. The time of the tamper, the alleged tamper was during work hours. He claims that he received notifications that the battery wasn't working, that he took it to Sentinel and replaced it. We tried to verify that. We were not able to verify that with Sentinel. However, Despite that, I believe that maybe those rubber boots that he had to wear that day because he was submerged in water at that point, probably had something to do with the device not reading appropriately. I mean, they're big, thick rubber boots that are waterproof. In addition to that, Judge, he is a father. He has a 1 year, 4-month-old, and the mother of the child that are dependent on him. He is the primary provider for the family. I've admonished him that he is not to do anything, no drugs, no alcohol, no nothing, can't mess with his device. If anything ever comes up again with his device where he has to go in, he needs to notify me. So Judge, we'd just be asking for him not to be revoked at this time and give him another opportunity. If the court would like to.
He's not gonna do it, right? He's testing positive for cocaine. I've ordered him not to use at all. I'm sorry. No.
If the court would like to do random UAs instead, Your Honor.
Or just what we're doing now. Goes with you. Your bond is revoked. Sorry, Ray. I can't. I mean, I was prepared to do that with that, but you're testing positive for cocaine. Unacceptable. I can't just let you go with that.
Yes, sir.
No, because then I become the enabler and I'm telling you, hey, man, it's okay for you to use. And it's not. No. I love you, Ray, but.
He's just gonna get a nice hold and.
Well, I don't know that, but hey, this is a second DWI. You already have a bond violation and now you're using? I mean, I can't just continue. I get it. He has to understand that actions have consequences. This is not our first rodeo. It's a second DWI and he's using?
Yes,
Sorry. Okay. 5,000. Tony. Ready.
Custody case.
Okay. Deputy Echegoyen, do you mind helping me out? I need someone brought out in back.
No, that's not right. Check. I'm sorry. Who's the plan?
I don't even have your signature. Where do you go ahead,
I know.
I granted your withdrawal on the other one.
I'm sorry.
I granted your withdrawal.
Okay, thank you. That's what we spoke about.
Yes.
Te vai escuchar aí, ok?
So this is with a new, Montoya, okay. Come on up, Mr. Montoya. Thanks. Mr. Montoya, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 50 days that you've done.
Yes.
Oh, he has another DWI. Did you see that?
Well, there's a question whether it's in.
So Freestone County has a hold on this gentleman for a DWI above a .15.
He doesn't acknowledge that, Judge.
He has a prior DWI from the same place. You need to realize something, Mr. Montoya, that this now may very well be your second DWI conviction because you're pleading guilty to this DWI. Once you have 2 DWIs, when you pick up a third, you're looking at a 3rd-degree felony, 2 to 10 at the penitentiary. Is that what it's going to take? Prison time? Some people only learn the hard way. Is what it's going to take. Watch the news. Every single day in our county here, someone dies from a DWI when it is extremely easy. One button on a phone of an Uber will take you wherever you need to go for $30 freaking dollars. From now on, you may be very well facing up to 10 years in prison, even with a sip of alcohol because of your record. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, You give up the right to appeal. Once you plead guilty, it will go on your record. It will be there for the rest of your natural born life. Do you understand?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
No culpable. Guilty.
Don't kill anyone. That's all we're asking. Don't kill anyone. We have enough death on the streets as it is. You have a DWI here. You have another one open somewhere else. You have one from last year. What's it going to take? I'm suspending your license. Is this pled as a first or is it pled as a second? I'm suspending your license for a year. Do not drive. Stop driving.
Think that it, flood is a first investigation.
I'm not asking for much, man. Really. Good luck to you, man.
Nice old judge.
He still has another DWI in another county, man. Really.
Driver's license suspicion?
1 year. Ricardo,
Yes, Judge.
you okay?
Yeah, just a long day.
I feel your pain.
Yeah.
You did? Okay. Maybe not the same one you guys like. No, we're two brown people. Brown people.
Hey, on Newton, are you ready?
I'm ready on the call. I just need
Mr. Pons, you ready?
Just check with the clerk and I.
It hasn't been called.
Miss New.
Which is great.
Marvin.
If he needs more time.
Okay.
No, I think we're,
We call him up. I just need to, we'll change the names because we're doing a name change.
but what about Newton? Are you ready?
On Newton, yes.
Can we bring her up?
Yeah.
Miss Newton, come up.
What's his name?
Yes.
Are you kidding?
I'm ready to start stuff. Yes. No.
That's hilarious.
Most of, you know the reason why that is, right? So it tells him.
Extremely judgment to be corrected. I'm gonna send this course
She's
directly.
pleading to one, and that's it. That's all.
All I want.
Like that.
So,
They want you up there. Look.
Oh,
No, Miss Newton, you here, you over there. Come up, ma'am.
oh.
Mr. Pons, you ready?
Wait. I need to sign, her to sign on the plate.
Okay, let me get it done and then I'll bring her. Okay. And is this one not, this one's not even on the docket, I guess, right?
It's on the docket. Oh, that one case is not on the docket. Yeah. Sorry about that.
okay.
It just feels good.
What are you
I am sorry, man. It's a feeling.
Miss Williams, or what is your true name?
It's Williams Newton. Thank you. I brought my ID.
Yeah, I gave him his ID, her ID.
ID says Newton.
It's Williams.
So it says Chrysanthia
Williams Newton.
Williams Newton.
Newton.
Okay, so we'll do a name change to that, whatever that ID says.
Okay.
You are charged with 4 counts of, I'm sorry, with, is it 2 counts of theft?
3 counts of theft, 1
3 counts
failure
of
to ID.
1 failure to identify oneself, giving fictitious information. You need to understand, ma'am, is that when you have multiple thefts, at some point they're going to hit you with a felony and you're looking at days instead of years. The agreement that you've worked out is they're going to dismiss 3 of the cases for your plea on 1. You have one prior theft, and it's very possible your next one may land you in felony court where you're looking at years instead of days. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand? Like I said, 2 thefts plus when you get a new charge, a third one, you're looking at a felony charge. Do you understand? They can use this to enhance your punishment. Not only that, from now on, you're looking at a minimum of 90 days in here for any new cases that you pick up. You understand? Do you still want to do this?
Yeah.
How do you plead to the offense of theft, man? Guilty or not guilty? I will find you guilty, sentence you to 12 days in jail. I'll give you credit for the 4 days if you've done. Good luck to you, man. Please see the clerk. Okay, thank you, Mr. Pons.
For now, and I'll call you up to do your collection form, okay? You don't leave until I give you a collection form. So you wanna? I'll call you back up, just have a second.
Okay.
You run the court cost? Okay.
If you're appointed, of course. This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, hey, man, if you blow and you're under, we're letting you go home, which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this case?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's
So
from
what case do you have? Can I
Sandoval.
see a copy?
Yeah, you can keep that.
Oh, I think I actually, Judge, may I? hand you-
No.
Okay.
They're talking.
Yeah. All right.
So Sandoval is almost the same thing as, or, I forgot the last name, but
It's the same thing.
I already know your position.
so.
I'm trying to get theirs.
It states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the statute outside the statute requirements of the DIC reading, but that it didn't
A court
directly
found that was not.
abuse of discretion from the trial court. Yes, Judge. For Sandoval.
Okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no, Judge. It's just case by case basis at this point.
Is it?
Yes.
Okay. Okay. So, have you seen the cases that they cite here? Okay.
I know these cases. May I point something out to you?
Sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. I mean, this is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed to,
100%.
whereas this one's more on point where I think it go either way.
It's 100% on point. And then what I wanted to point out to you was, I believe that was Sandoval that you were just reading.
Yes, Sandoval.
Okay, so in the in the Sandoval case, the court said the only case we have found, the only case they'd found concerning this very specific issue, the validity of consent given the hearing consequences of passing felon breath test, is State v. Sandoval. So they recognize that Sandoval is still good case law. They keep saying that Erdman overruled this case, and that's simply not true. This is still good case law, and I might also add Sandoval is in the Court of Appeals of Texas of Austin, and the case that I cited to you is the 14th Court of Appeals here in Houston, Texas.
Response?
Judge, nothing from defense. From the state. It is really just
Yeah, I
something to consider for the court.
I mean, I'm ready to roll. I think it's totally coercive. Absolutely. I mean, there's just no, I've never seen something like it, statement that, so I'm going to get locked up regardless, right? If you do breathe and you blow under, I'll take you home. If you do blow over on breath, then you're getting locked up. All right, I'll blow. I mean, really. If you blow under, quote unquote, I'm taking you home. If you blow over, you're getting booked in. If you do blood, you're getting booked in regardless, because blood takes 3 weeks, a month to come back. Yeah, I think it's totally, yeah. All right, I'm going to grant your motion as far as the breath.
Thank you, Your Honor.
Okay.
And Your Honor, just to give you, just to kind of maybe make this faster tomorrow, the state has also, we kind of touched on the motion in limine. And one of my motions in limine was to keep any testimony of the horizontal gaze nystagmus, the eye test, out of evidence because it was improperly performed twice. Once, the HGN that was given might as well have stood for here goes nothing, because that's kind of what it looked like. And then the second time, the horizontal gaze nystagmus test was just murdered.
We agreed to leave it out already.
So, okay, but I just wanted to clear that up for the record.
So just, admonish your officer accordingly. Hey, please don't get into this, and then that'll make it smooth. And then, yeah.
Absolutely.
Okay. Anything else?
No.
No,
Okay.
and we also came, just for the record, we did come to an agreement as to where the body cam would be redacted.
Okay.
And the portion that is redacted includes some statements that were on defense's motion for limine. So it becomes moot at that point.
Got it. Just make sure you watch beforehand so that you're okay with everything, so that when we do watch, it goes smooth and we don't,
Yeah, if I can get a copy of the one that they're going to offer into evidence today, I can
Do you
review it
have,
tomorrow.
do you have one
I
here?
I do not have a redacted portion of the body worn camera right now, but I can get it to you by the end of today.
Yeah, that's
I
fine.
can send it to
That's
you.
fine. I'm good with that.
All right, guys.
Thank you.
Thanks.
See you tomorrow. Counsel.
That person got an opt-out matter.
Yeah.
Cause number is.
Hi, Mr. Newley.
Good afternoon, Judge. So very busy today.
Almost done.
Cause number 2541895. That's Gascon.
Okay.
And Mr. Gascon is in the courtroom today. He needs to travel for his job and he's on the call-in, random call-in.
That
I
him over
spoke-
there?
That is him, Judge.
Okay.
I
So
spoke-
it's no travel restriction. If he gets called in to take a test while he's gone, he's going to have to go to a Quest Diagnostics, wherever he's located. Again, they're all over the country. I don't want Punka City Labs. It's got to be Quest Diagnostics, so it's ASCLD certified. We know that it's a legitimate lab. He gets the results to you guys, you get it to them, and then we're.
Thank you, Judge.
Thank you, Judge.
So here's the question I want every one of you to sit with. That sentence, perhaps prison is what you need, is not a threat. It is an honest admission. It is a judge saying out loud that he has run out of softer tools, that the warning, the fine, the license suspension, the probation in another county, none of it has been enough. And so the next step is a cage, not because anyone wants that, but because the alternatives have already been tried.
Say it again?
You want me to have like cases that are over 150 days and those are turned.
No, 180. 180.
Oh, 180.
Yeah, just, if it's at 150, just ask, is discovery complete? Because if discovery is not complete at 150, then we got a problem.
You could probably.
Whose plea is this? Do you know?
This one, this one, I was share the one that was like last minute, like then we set for tomorrow. We're just waiting on Plaza. He's in that street.
Okay.
And she should be on the way.
So I got the panel outside, so I give him 5 minutes just to use the restroom.
Okay. If you want to go ahead and let the lawyers know in the trial case, that there should be in one of the witness rooms that the panel is here.
Okay.
See if they're ready.
Okay. Yes, sir.
Please.
What time do you usually gonna be taking a break? I'm sure I'll be there.
I don't know. Let's see I don't know if we're even gonna go because,
Oh.
so let me see
Okay.
if they can work something out. I don't know. Hi.
Yeah, good morning. Raquel Williams. It's a DWI. We just need to, get medical records released. They're gonna file the motion. I just wanted to approach to see if we can make note of it. It can be done in the meantime instead of when we come back for that release.
You mean,
There's,
have medical records ready to give to them?
Yes, and we just need to file the motion.
Okay, so go ahead, file it. I'll sign it. As soon as you file it, I'll sign it. So it's old though. It's 184 days old. Do you have an offer?
we're supposed to be, trying to get PTI on it. She did a TRAS, the last.
So first apply. Don't just get the TRAS because, there's a lot of changes that have been made. So I've seen more denials now. So,
She's already done the TRAS.
oh, she's already done it.
Yeah, I had her do it when she was here last time because her appearance had been waived, so
Tell me, is blood test?
it should be blood from, it was a hospital visit, so, yeah, there was blood. It was like a point one.
What is it? What are the
Seven,
results?
I believe.
Results?
It's a point 1
I'm curious to see whether she's approved or if she needs a medication packet.
It was 10125.
What is it?
125.
Okay, okay, so it's not.
I did have, mitigation. I need to scan everything and send it over. I got, it
Accident?
was an accident. She ran into the back of a tow vehicle,
I think that you're
but still an accident.
still gonna need
Right.
it. Like this, they're gonna want insurance and all that stuff.
Right.
How much time do you want?
I can't hear you, Judge.
Shh. How much time do you want?
I don't, a couple weeks is fine with me. I don't need.
So
I'll be able
what
to
I would,
get the records.
so can you get the records to her today? Please file the motion. I'll send it now. That way we're ready with that. And then in the interim, we'll give you 2 to 3 weeks.
Okay.
But the next setting, if you can have everything turned in, and then that way we'll wait for a response, whether approved or denied. And I mean,
And then I have a question for you, Judge. Her license is valid now. And can she drive? She wanted me to ask for permission. Last time you told her to ask before doing anything. She's working, but Dad is taking her back and
I would
forth.
ask is just make sure that she has liability insurance, right? Make sure she has car insurance. If she has car insurance, then I'm okay.
James
with
told
it.
me he
As long
put
as
her
her
on.
license is clear and she has insurance, I'm okay with it.
Just want to document it. It's fine.
Alicia, on Raquel Williams, we ordered no driving. Can you confirm with her now? Ms. Moore? Can you confirm with her now? Does she have insurance now?
Dad replaced her on, I confirmed with him. He was here last setting with her and they were ready to confirm it then.
So they have car insurance?
It's not, let me find out if he actually, because I told him that last time, judge is gonna want to know you have it already.
As long as she has car insurance, I'll amend the conditions to allow her to drive.
Okay.
Yeah. And then after that, if she does, let Felicia know, and then we'll amend the conditions to allow her to drive, and then just get a reset with Billy, and then, yeah. Mr. Butler, are you able to work it out or no?
Work out some of the.
Just the case in general or no?
So they agree that my issue is, good and valid on that first case. And we can talk about it if you want to.
No, I get it.
Yes, sir. And we have to show you from the years, if you like, we can take you right through that second.
I don't think, and look, have you seen what he's talking about?
Yes. And I just spoke with,
And is it as in the motion, as they say, have you seen this?
That is a transcript.
the
Okay.
facts of the motion are as locally sentenced. Yes.
What do you think?
I actually just spoke to Alex and he said that case was recently overruled by a new.
Yes, Judge, the Arraignment case was overruled by the Court of Appeals, the Criminal Court of Appeals in 2012 by a case.
No, this is Serrano.
They cited the Arraignment case, the underlying.
You talking about Simon? It didn't overrule Erdman.
They state,
No, it didn't.
and I would like to, we can read it together. I would like to share it with the court. And
Last I checked, a Court of Appeals out of the Sixth Circuit or something does not overrule the Court of Criminal.
this is the Court of Criminal Appeals, Finan.
I'm sorry?
Finan is out of the Court of Criminal Appeals.
Okay, so tell me what it's, what's it?
1 second. So.
Obviously, we'll give you time to look at it so you can.
Yeah, no, it's still up to you. I've read fine.
And I would like to share it with you. So it says the rules developed by Arraignment's progeny are contrary to the fundamental rules to determine whether consent was rendered voluntary. Importantly, these rules, like the analysis of Arraignment itself, overlook the fact that the voluntariness of consent must be analyzed based on the totality of circumstances. And
That's what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control the voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Arraignment, which is what that Serrano case relies upon, is Arraignment.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that. Good law.
So, and I want to give you time to look at everything, right? But I mean, this is like right on point with this.
100%.
Right on point, right? So
And
if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's.
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, where an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home. And
Okay,
that's
so
what it said.
I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? Yeah, we need to get up there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Consider waiving her signature on that.
Yeah. Yeah, as long as you just can confirm. Okay, I trust you. All right. We are on the record in cause number 2505428. State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, AM. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Yana Davila for the state of Texas.
Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes.
This should.
Okay.
We're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge. So just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside the statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow And if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, and after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing.
And if you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes up on appeal, it is only reviewed for abuse of discretion. And the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the conclusion.
let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not
seen?
been overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, and that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly, you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
We have a panel here ready to go. So I don't want to keep them waiting. They've already been waiting for, 30 minutes. So how do you guys want to proceed?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this.
Well,
right after
the only thing that
I don't want to keep them waiting.
No, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that there is no breath test.
Of course.
So I think
I guess we're ready to roll. But and then we can.
I just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can.
Sure.
And then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the 2 outstanding case law that we have.
For sure. Okay. Any lawyers want to approach real quick before bringing the jury in?
Yeah.
Are you want to do your plea?
Yes, Judge.
Okay. Yeah, let's do it. All right, guys, if you're in the middle, we're going to ask you to please move over to the side because we're going to have a panel coming in and they're going to sit in the middle, please. So if you don't mind, please move it to the side.
I'm gonna need him to sign.
Yes, he's coming.
Huh?
I was hoping you could be finished briefly.
Yes, no, we'll get it done today. Hi, talk to me. Yes.
On Victor Navarro. This is an assault with a family member. His mom is here, who is the complaining witness as well. There's a protective order. I am requesting that the court lift the protective order. She is the only person to take care of him. I spoke with her this morning.
Spoke about a couple days ago.
No, this is new. This one is new for me.
It's on docket.
It is on docket today.
Is he in jail?
He is in custody. So I'm asking for 2 things today. One, a PR bond. He does not have any other violent criminal history. Also, no other cases pending. I'm not sure.
Let's read this. Shh, everybody keep it down, please. Hey,
Yes, Mom.
Alex, I'm going to read this. You ready? This is on Navarro. Okay, let me read this to you. This is why the magistrate did not give him a warrant, because I don't know.
Right, okay.
No adult criminal history, Harris County. No charges since 1999. This case, defendant is complaining witness's son. Complaining witness reports defendant got angry when he was asked to help move a shelf. Then later in the day, pushed complaining witness down to the floor and began punching her repeatedly, causing pain and scratches to her face. Defendant has been diagnosed with mental health issues. Complaining witness wants to press charges because he needs to learn his lesson and could possibly kill her one day if she does not take action. Her AFC defendant is not employed. Spanish speaker on AFC, English in court. Defendant declined PDO and appointment of counsel, but per PDO, he is 1622 consented to prior to docket allowed PDO to represent a PC. I need to talk to him. So, yeah. Yeah, let's bring him out.
Okay.
We'll talk. All right, come on. Bless, you ready?
Yes, Your Honor.
Okay, come on.
Yes.
You are Alberto Lopez.
Yes.
Mr. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out, I'm sorry, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. Is it being reduced to a first? It looks like it's being reduced to a first. What you must understand that this is still two. So if you ever pick up another DWI, you will be facing a felony charge of a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, I would never get into a car and drive if you have even had a sip of alcohol because you were playing, you're taking a humongous risk. Do you understand?
Yes.
You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there is no changing this. It will go on your record. It'll be there forever. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will sentence you to the agreement. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. Good luck to you, sir.
Hey, Judge, and Your Honor, I was appointed to this case, and I don't believe my client's financial status has changed since he's been in custody. Could we ask the court to waive the DPS fee? Thank you, Judge.
Come on. Good morning, Mr. Navarro. Do you speak English, sir? If you're going to play games, it's just not going to go well, man. You know, really.
Respectful, please.
Your lawyer's asking me to give you a PR bond, but if I know now that you're going to give me issues, I'm just not going to do it, you know? My soul, the only thing I want to do is protect the public. Do you understand? So your lawyer is asking me to, you know, give you a PR bond, but what I need to know is if we let you out, is there going to be a problem with mom?
Judge, I'm also going to do jail release instructions. So if we could do a jail release order so that he can go to the Harris Center. Mom is right here. Miss Francisca? The main concern, Judge, he needs to get on his medication. So I spoke with Mom. If we can do a PR bond, I can do a jail release order for him to go to the Harris Center.
Blas is still here. Do you speak English, man?
Yes.
Oh, wonderful. Okay. Are you okay if he goes back to your house?
I want, if you just wanted to get him like, getaway, that's what I want, you know?
So what,
I wish I could just find a place where they could put my maybe some month to make sure he is on the medications and stuff like that.
well, I can make it a condition of his bond that he's supposed to take his medication. And if he doesn't, then,
That's what makes him start acting out because I can't force it anything.
well, I am now making it a condition of your bond that, Mr. Navarro, if you want to be out on a PR bond, you have to take your medication. If you don't, then no more PR bond. Do you understand? I'm not asking for much.
He's not very, he doesn't even know how to talk to people and, you know, his mind is like sometimes not there, you know what I mean? He understands certain things, but I just have a problem with him. You know, he takes it out on me, not no one else, you know what I'm saying? But I don't want to get him spraying on him because he's gonna be on the street homeless, you know, and I can't let my son live in the street.
I got it. I understand. And I'm okay with it. Mr. Navarro, do you want me to let you out?
Let me out to my home house, you know, whatever.
You have to understand though, I want you to take the medication. Do you understand? If you do not, Mom is going to call us, let us know, and then you're going to be right back here with us. So I want you to understand the only thing I'm asking you to do is take your medicine and be nice to Mom. It's not hard. When you take the medication, good things happen. Can you do that for me?
Yeah.
You promise? I'm serious. So Mom, I'm going to give you, or you were going to give her your phone number. So if you have any problems, call her, let her know. She'll talk to me and we'll take care of business for you.
Tell him that if the cops show up, he's not gonna get out. He's gonna stay here.
Come on, everybody.
Yeah, you say that, Junior, because we're here in front of the judge.
Okay.
But you have to take life serious, Junior.
Mhm.
That hurts if you like this.
We don't want to keep you.
Okay, that sounds good. Yeah, but still, okay.
Next time you're getting out,
Okay, I know.
you better.
Okay, Mr. Navarro, make me proud, huh? Just keep taking the medication. Good things happen, all right? Okay.
Thank you,
Yeah,
Judge.
I'll grant it for you.
Thank you.
Okay, ma'am, any problems, just let us know. We're here to help you out, okay? Really.
So then it can't keep in the hospital like for a
What we'll do is
month.
we can, we can do jail release where we'll take him to the, no.
I will go to my holistic department and we will find resources for that. But I did explain to her that the Harris Center would just take him from jail, do the evaluation. They can't keep him there.
Problem is that at the Harris Center, we can't hold him. We can't
Right.
force him to stay. If he wants to leave, he can leave. We just can't.
I know.
That's why we will be in contact.
But they have resources at the defender's office to help you out. So whatever you guys need. And then just stay in touch with us if you,
I'm trying to get out of the journey, but I don't
We will
want
help
more.
you. We can help you do that.
we'll help. Okay.
Thank you, Judge.
Good luck, man.
That was for Navarro. Any bond conditions for?
No weapons and take medication.
Yes, Judge.
The state wants to approach on an extradition case. I oppose.
Your Honor, we're asking to approach on Nelson Morrow, call number 255-0421.
255.
0421.
Okay.
Your Honor, he is wanted out of Multnomah County, Oregon on 5 counts of sexual abuse. He's got a $1,250,000 bond. The demanding jurisdiction has requested a 3-day reset due to staffing issues.
Have you had a reset before?
I'm sorry?
Have you had one before?
A reset?
They
No, Your
haven't.
Honor.
They haven't. I have no object.
Okay. I'll grant it for you, but that's it.
Thank you, Judge.
Okay.
Thanks.
Thanks, sir. Okay, are you ready? All right, bring it on. Rock and roll. Tess, if you want to sit in the, Ramona, you're going to stay there? You don't want to go to where you normally go? Okay. All accounted for? All right, everybody, please be seated. Good morning, everybody, on this wet and rainy day. Good morning. Oh, thank you so very much for coming. You should really pat yourselves on the back. Really, I know that the weather's kind of crummy. I know that it's hot, humid, that most people don't want to be here. Look, I'd rather be at home too, but I really, your sense of civic duty, just, it's amazing. And I really, really thank you. And I love that we have such a great cross section of the community here today. That's what makes, criminal justice possible. A lot of other countries, a lot of other places don't have this. And that's what makes our system so great because, without you guys, we just can't function. My name is David Fleischer. I'm the judge here in County Criminal Court at Law Number 5. It is one of 16 misdemeanor courts here in Harris County. So just to give you a brief rundown, I don't know what you know, so I'm going to go from the top. So what are we? We are one of the misdemeanor courts. Well, what's a misdemeanor? Okay, well, in Texas, there are 2 types of offenses. There are felonies, and then there are misdemeanors. Does anybody know what the difference is? Anyone? Yes, so to speak. It's based on the amount of time. So a year and above, you're looking at a felony in jail. And below that, a year and under, you're looking at a misdemeanor. Now, within those two categories, there's always subcategories just because of there's so many different types of crimes, they have to subcategorize it. I'm not going to get into the felony because we don't deal with that here. I like to sleep at night and those is just, yeah. Anyways, so now within misdemeanors, there's three types. There's A, B, and C. Class C misdemeanor types are the type where, let's say you get pulled over for speeding. You get pulled over for no insurance, or, believe it or not, there's a Class C assault, disorderly conduct, whatever it may be. Depending on where you are in our city, because it's so big, you may go to municipal court, which a lot of people know about here on Lubbock. If you're out in Katy, you may go to a justice of the peace court. If you're out in Webster, or if you're out in that area, Clear Lake, you may go to one of the justice of the peace out there. So depending on where the occurrence happened is where you might go. Here in our criminal courts, our 16 county criminal courts, we deal with only B and A misdemeanors. B are punishable, anything punishable by up to 180 days and or a $2,000 fine. And Class A misdemeanors are those that are punishable by up to a year in jail and or a $4,000 fine. So we only have those two types that we deal with here in our county criminal court at law. Like I said, we have 16 of us because of the amount of people that we have here. And I will tell you now, percentage wise, I would say 7, maybe 8% of the people that are called upon to come for jury service actually show. It is such an abysmal rate that's why I really congratulate you on coming, because we really sorely need more people to show up, because like I said, without you guys, we just can't function. So what we have here, we have two sets of lawyers that I'd like to introduce you to. We have the state's lawyers, and then we have defense. State, would you please identify yourselves? Does anybody recognize them? Okay, defense.
Good morning, I'm Jim Butler. Pleased to meet you all.
Does anybody recognize Mr. Butler? Okay, guys, please. So what we have now is we're here for a trial. I don't think that anybody disagrees with the law in general. What they disagree with is perhaps how things happened, whether someone is innocent, guilty, and that's why we have you here. We are really not asking you to split the atom. We're not asking you to do Pythagoras' theorem. All we are asking you to do is use common sense. What's going to happen is a fact pattern is going to be given to you guys. All we want you to do is listen and make a judgment call. I have told this time and again to all the jurors that come here. You really know when you listen to someone in your heart, in your gut, whether that person knows what they're talking about or whether they're from outer space. That's all we are asking you to do. Any kind of preconceived notions, any kind of past things, we're going to ask you, or they're going to ask you, whether you have something that has happened in your life that would render you unable to be able to sit for this type of case. Okay, we're here on a DWI. And so they're going to ask you whether there's something that has happened. But at the end of the day, all we want you to do is listen and make a judgment call. Because you are the people that will listen, look at the evidence, and make a decision at the end of the day. So what we're going to do today is we will start with voir dire today, what we're doing, and then we will start with testimony tomorrow, and I anticipate that we will also conclude tomorrow. Is there anyone here that can't be here tomorrow? Anyone? Okay, you are 1, 2, 6. Okay. Is there anyone else that can't be here tomorrow for any reason? the last thing we want is we want you to get impaneled and then for some reason you can't be here tomorrow. It's still worse. So that's why it's okay. We just want to know, is there something why you've got plane tickets, a doctor's appointment, one reason or the other that you can't be here tomorrow? Okay, so. Now, it's not just because you want to like have lunch with someone. It's like, you got a serious doctor's appointment or, plane tickets, not just because you've got lunch with, So I got 5, 6, and 32. Is that it? Okay. Is there anyone here that is not comfortable with English? Doesn't speak English, speaks something different? Okay. And what number are you, ma'am? Okay. Anyone else? Anyone else? Okay. So what I'm going to do now is I'm going to turn it over to the lawyers. I'm going to give them each, about 25 minutes to speak to you, get to know you. I know it's a short amount of time to get to know someone, but the idea is that the only thing that we're looking for are people who really have an open mind and are fair. Literally just listen and then make a judgment call at the end. That's all we would like. Okay, are you ready? Okay, floor is yours.
Today's docket covered a wide range of cases, and if you watch from beginning to end, a few moments stand out clearly above the rest. A man pleaded guilty to his second DWI while already on probation in another county. The judge looked at him and said, "You scare me. You continue to get behind the wheel. At some point, you may kill someone." He suspended his license for a year, hit him with $4,500 in DPS fees, and told him plainly, "If you don't get it now, perhaps prison is what you need." He meant it. He said it slowly. He said it clearly. And then he told him to make them proud and sent him on his way. A man drove through an active fatal accident scene. Officers working the roadblock flagged him down with flashlights and verbal commands. He disregarded the barricade entirely. He was stopped, found to have a moderate odor of alcohol, and consented to a breath test, blowing a 0.086 and 0.084. Officers found a loaded handgun in the center console. 2 charges, no prior record. The judge set conditions and gave her 30 days to find a lawyer, with a clear warning. On a DWI, timing requirements are serious. Do not wait. A man pulled up a bus driver's route after she made an exception to drop a student closer to home, walked up to the open door, gripped the area near his hip where his firearm was, and when the driver said she was going to write him up, lifted his shirt to expose the gun. Said, "I got you." The bus driver closed the doors as fast as she could. He lifted his shirt, again as they closed. The judge ordered no weapons, no contact, and said, "As long as you abide by these conditions, you and I will be fine. But if I find you with a weapon, we are done." A man jumped fences, ran 100 to 200 yards from officers, and was taken into custody after running a red light while driving on a suspended license with an open warrant. The judge told him, "You are extremely lucky this is still a misdemeanor. A third evading charge is a felony." He made him sign an affidavit, "Do not drive," and told him, "If I find that you do, you are facing 6 months in jail and a $500 fine every single time." A man exited his vehicle when pulled over for unconfirmed insurance, refused to give his name, held his feet out of the door of the car in a way that made officers fear he was about to run or attack, and then, when finally detained, tensed his arms, concealed his hands toward his waistband, and continued resisting until he was taken to the ground. The judge found probable cause, put no conditions on the bond beyond following the law, and said simply, "You get into a pissing match with someone who has the power of arrest. Who wins? Just be careful. Life is hard enough." A man accused of stealing a leaf blower from a driveway was found in the back seat of a car. The leaf blower in the trunk, a loaded firearm under the driver's seat. The judge found probable cause, ordered no weapons, and told him, "Do not pick up any new cases. Do not become a danger to my community. Otherwise, I will revoke your bond, and you will not get another PR bond." And somewhere in the middle of all of it, a jury panel walked into this courthouse on a wet and rainy morning. The judge thanked them personally. He told them, "Only 7 or 8% of people called for jury service actually show up. That is abysmal, and that is why I congratulate every one of you for being here. Without you, we simply cannot function." He meant it. He always means it. A DWI case is going to trial. 12 people who showed up on a rainy Tuesday are going to decide it. This courthouse does not stop for bad weather. It does not stop for fear. It does not stop for people who run, or people who refuse to give their name, or people who have been told the same thing 3 times already. It opens the door, calls the names, and keeps going. We will see you in the next one.